Good afternoon, everybody. My name is Liz O'Neill. I'm a estate planning attorney based in Lexington, Massachusetts, and I am going to be sharing my screen in a moment to begin this presentation, which I hope you find helpful, practical, and useful to you. So, with no further ado, I'm just going to do that, and we'll get started. Hopefully you all can see that. If you're having any issues, please let us know in the chat. So the title of my talk today is 9 Things You Can Do Now, a probate attorney's tips to help avoid it triggering probate. My practice focuses on estate planning, and probably about 75% of the time I spend helping people put their plans in place, whether it's a will or a trust or other types of documents. But about 25% of the time, I help families after they've experienced the loss of a loved one. And it's really in that work that I kept running into these tips, I guess, these things that would trip up even the most well planned out estate and trigger probate. So I've done this presentation now a couple of times. I think it's practical, and hopefully you'll take something away today that will help you or someone in your family or someone that you're advising. So today's agenda for the next 40 minutes or so is just to sort of do a general introduction, an overview of what probate is. Some of you may have some experience with it. Some of you may have just heard bad things. I'll try to drill it down into a sort of a easy to understand way that gives you real information on what it is, how it works, and why people do try to avoid it whenever possible. And then we'll step really into the bulk of today's presentation, which is what can you do now? And I'll review 9 different tips and tricks. These are, again, things that I've just experienced time and time again that trip up the best laid plans. And then we'll summarize and take questions at the end. Quick disclaimer, this webinar is really meant for informational purposes only. Your particular situation or whoever you might be advising is unique. So do not rely on this information as legal advice. Consult your own estate planning attorney, financial advisor, and banker with regards to what you may want to do with what you learned today. So, by way of introduction, after someone dies, there can be a necessary court process. It's called probate. And its real purpose is to see that the decedent's debts and obligations are paid, and that clear title of anything they own passes on to their heirs if they had a will, or their devisees if they didn't. Actually, opposite, right? Heirs without a will and devisees with. And depending on what you own and how you own it, that process can be avoided. It can be easy. It can be more complicated. It can be time consuming, or it can be quick. And sometimes, again, avoided altogether. So what is probate? And basically, anything that you own individually in your name is part of your estate. The exception being assets that would pass by beneficiary designation. So a retirement account, for example, that's in your individual name, but that will pass when you die to your beneficiaries. So those types of assets that have a beneficiary aren't part of your estate from the probate's perspective. But for everything that's in your estate, the court just wants to make sure that it goes to the right person or persons, that someone just can't walk down to your bank with a copy of your death certificate and say, hey, my mom died, or my friend passed, here's her death certificate, I'm supposed to get her bank account. The bank might say, we're so sorry for your loss, but we want to make sure that that bank account is going to the right person. So the probate court is really meant to provide that vetting process to make sure that someone who's died's assets are going to the right people. So it deals with anything, by the way, also that isn't in a trust. So that's an important distinction that I just want to point out. Some times people have an estate plan that includes a trust, whether that's a revocable living trust or an irrevocable trust. But any assets owned by that trust, managed by trustees, that avoids the probate process altogether. So really what we're talking about here is not having to do with trusts. If you have a trust or your assets are owned by trust, then those assets will not go or need to go through any court process whatsoever. But other things that can't be put into a trust, like we'll get into that in a minute, like your car, for example, those can trigger probate. So again, that's the intention of today's discussion or meeting, is to help identify what those things might be and how you can do something now about them to skip this probate process. And the reason why it often can be beneficial to skip probate or avoid it altogether is, again, it can take time. On the short end, the shortest possible, I think, amount of time is maybe 6 weeks after someone's died. But it can go stretch on much longer than that, depending on the circumstances, the complexity, and lots of different factors. It's also a public process, meaning that when a probate is opened, there's a court docket that contains all the filings. It's outside the scope of today's presentation, but if we wanted to, we could go out and search any county in the Commonwealth, their probate docket, and search by someone's name, and you'll see any filings that are posted there. You can read their will. So a lot of people don't like that. They don't really want that their personal private information to be made so public, but that's part of the probate process. It is public. And it also typically involves a publication in a newspaper. Many of you may have seen those legal notices about someone who's trying to get appointed as a personal representative. That's also part of that public process. And third-party companies are paying attention to that. Once a probate is opened, it's very typical for family members or anyone who owned the assets or real estate, for example, to get solicited by a third-party company or solicitors trying to, benefit in some way. So that's a bit of an overview of probate and what it is. So let's get on to it. And what are these 9 things that you can think about doing now? And by the way, while I'm going to frame this in a way that's really speaking to those that are on this call, these are also ideas for those of you who have aging parents to consider. So keep that in mind. These are things that can be helpful in that regard as well. So number 9, beneficiary designations. I mentioned that earlier when I was talking about how, what is in an estate, and those assets that are owned that have a beneficiary designation, they pass when someone dies right to those beneficiaries. Many of us are familiar with the fact that our retirement accounts have beneficiary designations. It's always a good time when you're paying attention to a webinar like this is to double check your retirement accounts, make sure that they are updated and they are naming the right people. Things like divorce don't dissolve your retirement beneficiaries. If an ex-spouse is named as a retirement beneficiary, that ex-spouse will still be the beneficiary of that account. So beneficiary designations on accounts are a way to keep that asset out of that probate process. So retirement accounts, again, that's an obvious one, but annuities sometimes can have a beneficiary. It depends on the annuity, but I would check on that. Pensions can sometimes have a beneficiary. Sometimes they end with the death of the owner or the beneficiary of the pension, but again, always good to check. Investment accounts that are not either jointly owned or in a trust, those can have a beneficiary. The type of beneficiary is called the transfer on death or a TOD beneficiary. So if you have an investment account and it's not jointly owned with somebody, that's another place where you could consider adding a beneficiary. Residential refunds. So for folks that are in assisted living situations, sometimes those contracts have a refund. And it can be very beneficial to make sure that that refund is payable to either a trust, if the person has a trust, or to people, to individuals. Where this can get tripped up on is if that refund pays out to the person who was living in the assisted living, and when they die, that refund will be payable to their estate. And any checks or refunds that become payable after someone dies to their estate, in order to cash that check, you have to open up a probate in order to have an estate count opened. And even bank accounts, by the way. So many of us may have jointly owned accounts, and that's a very common way that if you're married, or you might have added your adult child to your bank account. But even those can have, in this case, it's called a payable on death, or a POD, and you can add a beneficiary to your bank accounts, which again avoid the need to open up a probate in order for your family or loved one, or whoever you've named in your will, to have access to that bank account. And by the way, I just mentioned the word will. This is also a common misconception that I just will mention while we're here. I've often heard from folks, they say, well, I have a will, so I won't have to go through probate, because they have a sense that, well, I did some planning, so that means that I can avoid that court process. And that's definitely a misconception. Every will, if it needs to go through every will goes through probate. So if you have assets that are being distributed by operation of will, it will need to go through probate in order to have the person you've appointed as your executor, or also known as personal representative, to have the proper legal authority to pass on that asset to whoever you've named in that will. Okay, on to number 8. Adding a joint owner to a safety deposit box. So a lot of people have a good common sense to maybe have a joint owner on a bank account. But for those of us who still have safety deposit boxes, and I know many people don't anymore, but they're still out there, you can add a joint owner. So it does involve taking that person, whoever you're going to add, down to the bank with you. They'll need to sign a signature card and be added to that, it's almost like a little contract or ownership documents that the bank has. And I highly recommend it. Sometimes people put sometimes even people put their will in their safety deposit box. But in order for someone to get to that will that's in that safety deposit box, they need access. And if they're not a joint owner, or if there isn't a joint owner in the family to get access to that safety deposit box, you'll have to have a probate to get to the will. Then that's a much messier probate and much more complicated than it needs to be. So, simple thing. If you or a loved one has a safety deposit box, seriously consider adding a joint owner so that they can have access to it in case they ever need to. Number 7, check your credit report. So you can check your credit report. It won't affect your credit to check your credit report. And it's always a good thing to see what's on there. Why? Because sometimes there can be old information. Sometimes there can be information that, or a credit card you got many, many years ago that hasn't yet been closed. You no longer even have the card, or getting even account statements. It's just good practice every few years to check your credit report. I did this recently when I was purchasing some property, and I was surprised to see what was on there. It's not all accurate. So it's just a good idea to see what might be on that credit report. This maybe isn't quite as impactful as some of the other tips, but what can happen is, if you have an account that's still open somewhere, or you have something on that credit report that needs to be dealt with after you die, that also triggers a need for a probate. So it's just a good thing, just a quick thing. There are 3 different bureaus. You can check all of them or one of them, but just see what's on there and make sure that the information that's on your credit report is accurate. Okay. If you have out-of-state property, so if you have a cottage in Maine, or a place you go in New Hampshire, or anywhere else, really think about how the deed is titled. So when someone dies owning real estate in another state, and if, say, the deed is only in their name solely, in order for that property to pass on to their heirs or their devisees, there'll need to be a probate in that state as well. So sometimes people in Massachusetts, Leslie's used, for example, because that's where I am, will have taken care of everything in Massachusetts by either adding those beneficiary designations, putting a joint owner on their accounts, making sure that everything is just squared away and completely organized. And they have that cottage up in Maine, and they think that just because it's in their will that says, please pass on the cottage in Maine to my children when I die, that they've done everything they need to do. Well, that type of scenario, what that will mean is actually then their family, in order to properly transfer that property in Maine to those children, will need to have a probate first in Massachusetts, and then a second probate, it's called an ancillary probate, in Maine, in order to just transfer that deed. So there are ways to plan around this. You might put that property in a trust. A trust, the Massachusetts trust, can hold out-of-state property. So you could transfer by deed that property in Maine to a trust, and then that it will pass much more easily. There'll be no need for probate in Massachusetts or in Maine for that matter, and it'll go on to whoever you want it to go to. Sometimes people also consider adding their children to a deed during their lifetime. That's another common thought process. And while that idea, or that approach, I should say, will take away this need for a probate, it does create other potential issues that may be unfavorable. One in particular is the way that the cost basis will be treated. And I don't want to get too deep in the weeds on this, but there are advantages to, if it's your children or to whomever you're passing on, say, a piece of real estate, there are some advantages from a tax perspective for them to inherit it when you die, because the value of that property steps up in value to whatever it's valued at the date when you die, so when someone dies, versus the date when they bought it initially. This can have pretty significant impact in terms of the potential future capital gains. So before adding your children to a deed, or before anyone does that, they really need to understand the trade-offs there. They might be getting around this problem with probate, but they might be creating some other issues that also have to do with gifting, which again are a bit outside the scope of today's chat discussion, but it's definitely something to make sure you have good advice about before you do anything. Moving on to number 5. Check abandoned property in any state where you've lived. So here in Massachusetts, there are often you'll see advertisements from, I think, Secretary Galvin. Hey, it's called Find Mass Money. If you haven't already done that in Massachusetts, I highly recommend that you do. It's really amazing how many people have an uncashed refund check, or a stock dividend, or something, an old bank account that maybe you opened a long, long time ago, back when there were passbooks, and just something that you forgot you even had when you moved out to a different town or different community. So that local bank, after a certain amount of time, will close that account if they haven't been able to contact you, or you haven't responded to any correspondence, and they'll put it in abandoned property. Every state has an abandoned property system. In Florida, it's something called, the Florida Treasure Hunt or something. It's got a really a more creative title. But the reason to do this is because it's surprising. Actually, you might find that you do have abandoned property in a state where you used to live. I went to college in Pennsylvania. I had no idea that I had some uncashed checks. I did this shortly after giving this presentation for the first time, and I actually checked Pennsylvania, and sure enough, I had a small nominal refund from AT&T, but I was able to get it and have it. And while it's true that most of the time, the vast majority of the time, if you do have abandoned property, say a Find Mass Money, it's not going to be a lot of money. It's going to be a small amount of money. It might be a few $100s. It might be less than 20. But I can tell you from your family's perspective, after someone dies, if they check and if there's anything on abandoned property, they're often very prone to want to figure out what that is, and feel like they should you know, process the claim so that they can get that abandoned property. And that triggers a probate. You can't do that without being appointed as that estate's personal representative or executor. And even if it's a small amount, and even if the family knows that it may not be worth much, there's sort of some sort of dissonance for families, I found, knowing that their parent had some abandoned property. They feel like they have a responsibility to go get that property out of the abandoned property place that's held by the Commonwealth. So again, it's easy to track down. Every state has a system. Go take a look and see if you or a loved one or your elderly parent has any abandoned property in any state where they may have lived. Okay, for those that live in the Commonwealth of Massachusetts, and if you own real estate, you probably don't know because you wouldn't need to know. This was not something you chose. You had nothing to do with whether or not the property is recorded or registered land. It just is a fact that in the Commonwealth of Massachusetts, there are two systems that are used by Massachusetts when it comes to taking a big piece of land and breaking it up into parcels that then turn into real estate. Sometimes it's called recorded land, and that's handled by the Registry of Deeds. Actually, the Registry of Deeds helps to handle both recorded and registered. But for those parcels that are registered land, those are the deed transfers and the management of how that land is managed is handled by the land court. And what that basically just effectively means is that there's sort of higher level of diligence around any property that's a registered land property. And when someone dies, it can trigger additional hoops to jump through for registered land. So if you do this research, and I'll show you or tell you in a second how you can determine whether or not you have recorded or registered land. If it's recorded, nothing to worry about. If the property is in a trust or however you want to pass it on to your loved ones, it's not any more complicated than anything else really that you own. But for folks, if you find out you have registered land, if you're married and you've registered land, if you're the first to die, there's a simple process that parcel can transfer to your spouse, and it's called a certificate of title. It's associated with your deed, but there's a separate certificate of title for that. But if you're the second to die and it's registered land, that will not only trigger a probate, but it triggers what's called a formal probate, which is the highest. I'm not going to get into distinguishing the different levels of probate in Massachusetts, but the land court requires the highest level. And whoever's, again, this is for property that's not owned by a trust. If this registered land property is in a trust, you don't have the same problem. But if it's not in a trust and it's registered land, then before a new certificate of title can be created for the new owners, it has to go through the land court. And the land court, there's only one land court in all of Massachusetts. It handles everything with regards to registered land. And these types of new certificates for a new owner really fall to the bottom of the pile when it comes to what they prioritize because of all the different matters they're dealing with. So it can take a long time. It eventually will happen, but it definitely will trigger that probate, which was, people would like to avoid in general for the comments already shared. But then also just dealing with the land court is very frustrating at times and can be over a year for them to even address your matter. So the way you find out is just simply this. Go to the Registry of Deeds. When you go to the Registry of Deeds, if you just type in Registry of Deeds, Google Registry of Deeds, it'll take you to a little picture of the Commonwealth of Massachusetts broken down by county. Just click on your county, and then you'll be prompted in the upper left-hand corner to choose. Just start with recorded land and put in your first and last names and see what shows up. And when you see your deed, if it's in recorded land, that's where you'll find it. If it's not there, then you can search under the registered land menu. Same way, you can use your first and last name, and you'll see whether or not you've registered land or recorded land. Okay, consider your car. ownership of a car by a surviving spouse is often what can trigger the need for a probate. And I've seen this more times than I care to share. Again, for folks who've done all the right things and all the planning, added the beneficiaries, thought about things, even if they have a trust and everything's owned by the trust, cars can't be owned by a trust. The Registry of Motor Vehicles don't allow it. Car insurers don't like it. So the car is almost always owned individually. Now, if you're married and you pass owning your car, the Registry of Motor Vehicles does have a very simple way for your spouse, without going through any probate, to transfer the title of that car to themselves. So that's not a problem. But if this is the second to die in a marriage and they still are driving and have their car, or even if they're not driving and own their car, if that car, that title of that car is in their name, the only way to transfer that after they die is to open up a probate. And then once the person's appointed by the court, they can then transfer the certificate of title. So this can be extraordinarily frustrating. Even, oftentimes, the family is just wanting to transfer that car to another family member, to a grandchild or a nephew. So it's not even to sell it. But this would be true in either scenario, whether you're just trying to transfer that certificate of title to a non-spouse or to I'm sorry, not to a non-spouse, to another family member, versus even just selling it to Carvana. In order to properly do it, you need to have a probate. So that's just something, especially if an elderly parent who still owning their car and they're no longer driving, it's a great chance to just have them sign over that certificate of title, and deal with that car sooner than later, because this is often one of these really sneaky assets that poke into this process and disrupt what otherwise would have been a perfectly administrative process, and that triggers a probate. Passwords and digital assets. So much of our lives right now is with email or photos or Facebook or whatever the things we may use online, and on online accounts and access to them. From a legal perspective, once someone has died, you can't access their accounts unless they've given you permission. The law has really been slow to catch up on this. Now, I know on a practical level, I know plenty of people that continue to log into the decedent's accounts. It's not legal to do that from a lawyer's perspective, so I don't advise that. I can never advise anyone to do something that's not legal. But this is often something that you should take time to work out. There are a lot of good different systems. I know clients of mine that use 1Password. I don't use it. I've been slow to get to do that type of stuff for my own personal assets. But it is definitely something to think through, how you want to pass on information about your accounts. I have noticed lately that there are more and more ways. Facebook has a legacy contact. Apple allows you to add a legacy contact. So there are definitely ways, depending on the provider, that you can add a successor, someone who is authorized to access your accounts. So definitely look into that. I do think the law will catch up to this, and I'm hopeful. But in the meantime, you want a plan in place to be able to have access to online accounts, because so much again of what we own is online, and especially photos. I think about all the amazing photos that I rarely print out photos anymore, and I would want those photos to be able to pass on. So there are ways to do it within each provider, and I highly recommend folks to look into that in order to make sure there's kind of a seamless transition for digital assets. And for anybody who owns cryptocurrency, that's even more critical, because as if you own it, the passcode and the access to it is imperative in order to gain access to those types of assets. Last but not least, do you have an estate plan? So one of the smartest things that you can probably do in order to make things go easily and to avoid probate is to have some sort of estate plan, whether that involves a trust and then will completely avoid probate, or or even if you do have a will, that will go through probate, but you can do lots of other things with those other assets in terms of joint ownership, adding beneficiaries, in order to set things up in a way that's going to make things go as easily as possible for your family. There are two things that are, as an estate planning attorney, I hear almost all the time. One is when I get a call from someone new, they'll say, "Oh, I've been putting this off." Because no one wants to think about their death, right? I mean, it's not really at all something that we want to grapple with. We want to think about. I think that's somewhat universal. So this is often is a task in terms of creating an estate plan that goes to the bottom of the heap. It's easy to sort of just get to it. We'll get to it later. So it's probably the most common thing is that most people have put it off, and when they call me, they said, "Oh, I've been putting this off forever, but I need to do it now." Um, and the second thing that I hear that's probably one of the most common things is I just want things to go easily for my family after I die. Many people have had the unfortunate experience of helping to administer an estate after someone's died who hasn't done any planning, and they may own lots of different types of assets and have different accounts, and it's a lot of work. And for folks who've gone through that, and anyone on this call, if you've gone through that, you know it's a lot. It's a lot of work. It takes a lot, and it's a lot of energy to handle it. So I think that's where so many people do want to have simplicity and have things to just be easy and to have things organized. And that's where working with someone to help craft a plan for you can be really, really helpful. There's some other thoughts that I wanted to share that are adjacent to all of this. You're thinking about funeral instructions. That's a really simple thing that you can do. If you care, if you have thoughts about it, it's really helpful guidance for your family. I have a client who wants nothing. You know, she's adamant that she doesn't want anything. She doesn't want a funeral. She doesn't want a celebration of life. She's very specific about what she wants. And I said, well, that's important for your family to know too. So even if you fall into a camp where you don't want a funeral and you're not interested in that, that's a good thing to communicate to your family so that they know. Your paperwork, organize your files. It all probably makes sense to you. You can probably find things, given a little time and you know where they are. But when you're no longer here, it's much trickier for your loved ones to find what they might need. So just think about organizing it and think about where you want to put things and make it easy for them. Credit cards, loans, life insurance policies, keep a list. Don't put necessarily the account numbers on that, but just have a place where you have that listed out. If you work with a financial advisor, put their name and phone number. It's super helpful. If you, after someone's died, if there's some sort of list that gives your beneficiaries, your children, loved ones, just a head start on figuring out what is it that you own. I kind of call it an inventory. Just keep an inventory. You communicate, share information. This promotes family harmony. When family knows sort of what to expect or what your thoughts are, it can really help get out in front of any potential issues. It's really always striking to me, especially after the loss of a second parent, how the family that's left, the children, really are lose their balance for a while. I think it's very disarming, that experience of no longer having parents. And so it can be a time for real family unrest. But if they know there's a plan and they know sort of what's meant to happen, it can really be helpful. And then your pets, make sure you have plans for your pets. That might be obvious, but it's always good to do. Okay, so in sum, hopefully you've sort of picked up a few practical tips, guidelines for things you can be thinking about with regards to planning. These are just some. There are many others. I would say, though, the only other thing that alongside this in terms of, and by way of summary, is make sure whoever you work with, and this might sound really obvious, really listens and is someone you can really talk to. As you work through these issues, and if you think about creating an estate plan, you want someone who is going to explain how things work and break things down in a way that you understand. Because sometimes it can be confusing. There are lots of different types of trust out there. There are revocable types, which serve a certain purpose. There are irrevocable types that also serve a purpose. Sometimes those have to do more with protecting assets from nursing homes or potential liens. There are realty trusts. So there's a lot, and it's confusing and not, your solution that's the best approach for you is going to be different than somebody else. And working with someone who can explain it and answer questions is really important so that it exactly is going to be how you wish it to be. So with that, I just want to thank you for attending. I'm happy to take any questions. And also, Rick, if you wanted to add or a comment on anything that I just have covered.
Yeah, no, this is great. I do have a question here. Let me just read this. As a single person, it seems that adding my children to the deed is not a good move. Would a trust be the best option to avoid probate?
Oh, for avoiding probate, absolutely. And it also allows for that step up in basis. So I alluded to that earlier. If people are added to a deed during lifetime, they get your carryover basis. So whatever you paid for the house becomes their basis. So then if, for example, after you die, if they decide to sell it, there's going to be a capital gains issue that can be avoided by putting it into a trust and having it pass on to them when you die. So trusts are really good at passing real estate from one generation to another. The other thing that happens when children are added to a deed is that's considered a gift. So depending on your circumstances and whether or not an estate tax is going to be at issue, and what I mean by that in Massachusetts is every one of us has a certain exemption amount. It's $2 million. And if your estate is over $2 million, there could be an estate tax due to the Commonwealth upon your death. And if it's under that amount, no tax is due. But any gifts made during your lifetime, like for example, gifting real estate, say the value of that gift was $500,000, and I'm just using simple math here. What that in essence means is you've just used up $500,000 of your exemption amount. So now your exemption amount is $1.5 million instead of $2 million. And that gifting issue is something that is really important to understand before adding your kids to your deed, because it's considered a gift of value to them, even unless you're going to have them pay for it, which nobody I know ever has their child actually give them money for putting them on a deed. So long answer to your question, but bottom line is a trust for single people, or if you're not single, can be an extremely effective way of passing on real estate to your family when you're gone.
That's great. Lyme and I have been doing this a long time, and we've helped, people settle these estates that have passed away. And the idea of having that document that lists who to call, where the stuff is, it really can make a huge difference in the family members that are left behind. We've been working on a piece like that for a while. We're hopefully going to wrap that up soon and get that out to clients. So I think that's a really great tip, because I know that when someone passes away, there's just so much emotion and anxiety that can be surrounded by that anything you can do to alleviate that for the family members is pretty huge.
Agreed. I'm going to stop sharing my screen now. I can come over here. There I am. Okay. Any other questions? Can I answer?
Let me check the chat box again here.
While we're waiting, I have a question that comes up a lot, Liz, which is there a way for me to put everything in trusts or various structures so that I don't have to go through probate at all, like completely eliminate it? And if so, is that always a good idea?
So yes, there is a way to completely avoid probate, and a lot of that has to do with having a trust and having assets owned by the trust. All of your assets except retirement assets, which won't be owned by the trust, those will go by beneficiary designation, and that's the type of planning that a lot of estate planning attorneys do. Is it a good idea? It depends on your circumstances. I obviously have a bias towards it because it's what I do and I've seen it play itself out. The downside sometimes can be is it's more expensive, to set one up to begin with. So while you're alive now, there's an investment being made towards that type of an estate plan that has trust planning. There are other advantages to it, though, that we didn't even talk about for married couples, and they have to do with estate taxes. So that can be a value that's, well worth it, even beyond the probate avoidance benefits, but from an estate tax perspective, and that's a good topic probably for another webinar. But I see no downside to putting things in a trust and having the assets owned. The other advantage to it, beyond the probate avoidance piece is if you become incapacitated. So if anything happens to you, say you're in the hospital, you're unable to take care of your affairs, your successor trustee named in your trust can step right into your shoes and manage your assets on your behalf, which is a huge benefit. Powers of attorney are meant to do a similar thing. However, they sometimes don't. Sometimes they're highly scrutinized and the financial institution will reject them. And it's at the absolute worst time that could come up. Whereas that just doesn't happen with trust. The successor trustee has the ability to step right in. So trust can play a really valuable role in while you're even alive. Definitely probate avoidance upon someone's death. And for those who have assets where it becomes important to understand the estate tax issue, especially for married couples, there can be real benefits in that regard as well.
Thanks.
Hi, Liz. I had a question about other items, not cars specifically, but jewelry, artwork, antiques. Can you put all those things into a trust as well?
You can. So you can assign, so that's legally the word is tangible personal property. So artwork, jewelry, autograph collection, anything of monetary value, but also things of sentimental value, you can assign to a trust. And then the trust will typically reference a memorandum of tangible personal property. And so what you can do is if you want to designate a particular person to get a particular item, you can put that on that memorandum. By default, whatever you don't designate will just go to your beneficiaries named in the trust document. So items of tangible personal property can also flow right to a trust to your beneficiaries. It can also go by will. So a similar process can happen in your will. You can determine that anything tangible personal property can go by operation of your will, and that doesn't necessarily trigger a probate in and of itself if there's no other reason to have a probate, except if the item itself has some sort of certificate or license that needs to transfer ownership. So if you need to show that there was an ownership transfer, many items of tangible personal property don't have that. So you can just give the item to the person. But when they do have something of that nature, it's helpful to have it go through the trust instead of the will. Great question.
So Liz, I have a question pertaining to like durable power of attorneys. And you and I have talked about this a little bit in the past. How often or what's the best procedure when someone has one of those that, let's say, they've brought to their bank, the bank's accepted it, that they should update that to keep it fresh to make sure that there's no problems down the road?
Yeah. So the going sort of rule of thumb is at least every 5 years. I've heard attorneys say 3 to 5 years. And that's sort of, I'll reach out to my clients around that time frame, set up a meeting, reconnect, and have them just, even if the document does not change at all, just as a fresh signing date, because of this issue. So definitely worth, if you've done your power of attorney, but if it's older than 5 years, just contact your whoever you worked with, just re-sign the power of attorney, have a fresh signing date on it. It's such a huge problem when it's needed and it's not being able to be used. By the way, I might mention too that there are also, with a number of different financial institutions, custodians like a Fidelity, where you can sign, they have their own power of attorney document that you can you can go online and sign, and then there's sort of you're using the fidelity power of attorney document. The one downside to that, and I just will point this out to everybody, that I more recently became aware of, is when you do that, if you do that, or if you have a client who does that, the person that you've named as power of attorney has full access to be able to see your account right now. So they can log on and see what you own, how much you have, and all that stuff, which typically I found my clients really don't like. They don't like that. They want to keep what they own or how much they have in that Fidelity account private. Especially sometimes parents. You know, their power of attorney might be their adult son, but they're not at a point now where they want their adult son seeing how much money they have in Fidelity. So it can be very practical to say, for example, work directly with that financial institution, add your power of attorney right now through their form, and not relying on the form you got from your lawyer's office or wherever you got your form. But it does come with it somewhat of a lack of privacy, at least with regards to Fidelity. I'm not sure if that's true everywhere.
Can I ask a question going back to the car? If a parent had a car, and I understand that because it would have a title, that would have to go through probate, what was the suggestion? Because to have the parent transfer the title now would also raise some concerns for me about liability on the.
I meant only if they were not driving anymore. So the only thing about if they were done driving and using the car, you're right. If the parent is still using the car, do not touch the certificate of title. They still own the car. They're still the insured on the car. So it's just something to keep in mind, you know, towards closer to, again, when they're no longer driving or towards end of life. Sorry. Thank you for clarifying that. I'm sorry if that was confusing.
It's something I had thought about, so I appreciate that. Thank you.
Yep.
And Liz, going back to the bank situation, not the power of attorney, but if you have a married couple or two people that are on an account, could be a mother and a daughter, for example. I think we had chatted about this a while ago about which social security number is listed first versus second, and if the first person who's listed passes away and the remaining account holder is the second person listed, that they might have some issues closing that account out. Can you speak on that a little bit?
Yeah, so it isn't consistent with all banks. So, but let me explain this, because it has come up for some of my clients, and it's been a real surprise. So many people with an elderly parent have been added to that elderly parent's account to have a joint account, typically for convenience, helping to pay bills, making sure that things are organized, and whatnot. And also with the thought, so when that elderly parent passes, that account then will just be able to be used by the daughter, say, for example, to again pay the funeral home, pay any last medical bills, so forth and so on. So it's usually done for convenience and not necessarily even for any other reason. But it has happened where, so when someone dies, their death certificate is issued, the Social Security number that's associated with that person is on the death certificate, and it does get sent to the Social Security Administration. So right away, the Social Security Administration is notified if there had been any Social Security payment that had been made after the date of that someone died. They'll take that money right back out of the account, sort of automatically, and they will freeze the account. Now, some banks will release that freeze once they see a death certificate and they see, oh, yep, you're the joint owner, and that's fine. But I have had times where the bank has required the joint owner even to get appointed by the court. That happened recently, actually, at Bank of America. So that isn't every bank, though. That hasn't been every situation of every one of my clients. So it does vary, but that Social Security number gets frozen, and again, the bank wants to make sure that whoever is going to have access to that account is the right person. And it has been really surprising when the bank has required an appointment from the probate court in order for that adult child who's a legal owner of that, a joint owner of that account, but because their Social Security number was not being used for it, that could be problematic. Now, the problem with, well, another suggestion somebody could say is, Well, why don't you just have that adult child have the bank use their social security number for that bank account and just switch it out? But it's not so easy. Once you change that social security number, then that account number is going to change, and now it's basically a new account. It still may be joint with the two owners, and now just using that adult child social security number. But now you've completely disrupted that elderly, and they probably have social security going in automatically to that account. And good luck dealing with Social Security Administration and getting them to update where they're going to make that direct deposit. It's a nightmare. You can do it, of course, but my point is, a lot of times we're not trying to make things more complicated. And by changing that Social Security number, you're basically opening up a brand new account, and anything that you had automatically coming in or out of that is now going to need to be updated. So,
Sounds like a mess. So I guess the answer there is maybe a trust, like a revocable trust would be a preferred way to go than a joint account.
it could be, or really go down to the bank, like talk to the bank. Like I would advise for folks who really want keep that joint account, just check in, have a relationship with your banker, make sure they know, what the situation is, and ask them this question. What happens when my mom dies and her social security number is going to be frozen because it no longer can be used? Will this account be frozen? What's the process? And see what they say.
Okay, great. We have one more question. Dribble power of attorney ends upon death, correct?
Correct.
Right. I wrote that, and I think that's really poignant. I went through that with my own parents, and I think that's really valuable. I didn't know anything about the successor trustee can assist even while they're alive. And
That's
I think that is such an important having experiences. And the reason I'm on this is not that I've gone through some of this with my mom and dad, but I have a father-in-law who is negligent in doing a lot of this. So this is some wonderful information for me to be able to bring back to my husband and his siblings. And
Great.
so to me, that is so salient.
Great. Good. All right. Well, this has been a real pleasure. Thank you all for making time today for this webinar. Rick, thanks for having me.
Thank you, Liz.
And I hope it's a beautiful day. Get outside, enjoy it as best you can. And again, thanks again for having me. Much appreciated.